Good afternoon, and welcome to the Appellate Division First Department. We have about 6.5 hours of requested argument time. So I will call the calendar. I'm going to ask you to ask for that time which you actually need, not the time that you want. We are familiar with your briefs, with the record, and please know that while I may shorten your time, if my colleagues have additional questions, I will not interfere with that. So if your argument is excellent, you can keep talking. All right? First case on the calendar, People versus Jose Salvador. Submitted. FARCA versus Board of Education.
5 and 4. Respondent request 3, Your Honor.
5 and 1 and 3. C. Pedro versus Michelle R. is submitted. Marquez versus 171 tenants.
Respondent request 5, Your Honor.
7 and 2 and 5. U.S. Bank versus Barker Project. Okay, let's do 4 and 1 and 4, and if, like I said, if my colleagues have questions, I'll keep it going. People versus Lamine Niji. Okay. 4 and 2 and 4. 35th Street versus 7 and Up Clothing. 5 and 1 and 4. Archives LLC versus Volpe. Okay. 5 and 2 and 4. San Lee Oriental Rugs has withdrawn their appeal. People versus Alberto Vallejo. 4 and 1 and 4. Conti versus Ruiz.
The appellant, 33 minutes, Your Honor.
Okay. No one else. You want to submit?
If your honors have no questions, then I will submit.
I think we're good. Calderoni versus 260 Park Avenue South.
Appellant 8 and 2. Respondent 7.
6 and 2 and 7. Bausman versus Panda Enterprises. Submitted. New Millennium versus Progressive Casualty.
Appellant 5 and 1.
5 and 1 and 5. Chelsea 8th Avenue versus Chelsea Milk.
Appellant 5 and 2.
Respondent
5 and 1 and 5. People versus James Melbourne. Submitted. Jabelki versus Board of Managers.
Appellant 5 and 3.
Respondent
5 and 1 and 5. Gilead versus Sutton is submitted. First case on the calendar. FARCA versus Board of Education. And I did receive the additional citations. You may proceed, counsel.
Good afternoon, judges. Jimmy Wagner for the appellant, if it may please the court. The first issue I would like to address is I apologize humbly to this court. I was unaware that in COVID, we were no longer following traditional case law. And I would have looked for case law that was associated with COVID when I was referencing primary issues such as statute of limitations. Because the statute of limitations issue historically in this court, in the Article 78 employment context, begins to run on the date of termination. Judge Frank and the lower court stated Article 78 statute of limitations runs on the date of notice. Historically, this court, the Court of Appeals, and the law has always said it's the date of termination. Judge Manizette Daniels, in your case of Allen A. versus Department of Education, you clearly outline the effective date of the statute of limitations begins on petitioner's termination.
Counsel, I understand where you're trying to go here, but the issue here, in that first notice that was given, wasn't that in fact the termination and said that she didn't do anything, get the shot within 7 days, that was it?
No, Judge, you're wrong.
I'm wrong?
That's absolutely correct. I would request that you look to the record, and if we look to the record, the actual date that the employment's termination is page 62, and that's March 17th of 2022. When the original notice is given, the original notice gives the appellant 7 days to take curative actions.
But that notice was also a notice of the final determination by the arbiter, right?
No, it was by the citywide appeal panel, aka
Which was the substitute for the arbiter. They created the city panel to deal with these arbitrations in particular because there were potentially going to be over 3,000 of them,
Judge, again, the
right?
facts
So
are
a city panel
incorrect.
was put together in order to deal with these specific kinds of arbitrations, correct?
Incorrect, Judge. The
No.
record reflects page 262. It was not 3,000 tenured teachers. It was
I didn't
500.
say 3,000 teachers. I said 3,000 applications.
It was 3,000 total applications. I'm not aware of where in the record that refers to teachers. Teachers are a unique
Again,
class.
I did not say, so counsel, I need you to not misstate what the court says, right? I'm still talking. So when I said they would have dealt with over 3,000 applications, I did not say 3,000 applications from teachers. So don't misstate what we say.
Your Honor, I'm not misstating anything. I believe you're misrepresenting the record. The record is very clear that it's 500 tenured teachers. Prior to COVID, you could never remove a tenured teacher from a term of teaching without a hearing. This court said because of COVID, tenured teachers lose their 30/20 due process rights. So this is unique circumstance. Kane versus de Blasio in the Second Circuit, they found the original due process accommodations given to tenured teachers to be constitutionally suspect. My client's not only protected by the U.S. Constitution, but the New York State Constitution, Your Honor. This was a rubber stamp denial. And in reference to the statute of limitations issue, it has far-reaching effects because now Judge Kotler states, I agree with the Honorable Lyle Frank, who states that the 4-month statute of limitations begins to run from the date of the administrative decision. The reason why statute of limitations doesn't run from administrative decision is because every agency will turn around, issue a negative decision, wait 4 months, and then terminate, depriving my client or that individual, again, from a fair judicial review.
That's not what happened here, though.
That is exactly what happened, Your Honor. My client required a fair judicial review. It never happened at the lower level. The judge took the route of Pontius Pilate, washed his hands of this matter and said, I am no longer going to entertain this case. 4 months? This court, you, Judge, have stated it's the date of termination. There's no reason.
Counsel, I'm just trying to understand why the March 7th letter wasn't in fact the termination date when it actually inflicted the injury on that date. She didn't do anything, she's done.
Because the March 7th letter doesn't terminate her. The March 7th letter says, go get vaccinated. The date of the termination
Or you will be terminated.
is March 17th. But they could have adjourned that out for another 30 days. My client is completely unfamiliar with the processes involved by the DOE.
You'll have time on rebuttal.
Good afternoon, Your Honors. May it please the Court, Philip Young here on behalf of the respondents. I just want to briefly address Hogue v. Board of Education. That's a decision this court filed just this morning, affirming in a substantially identical case the citywide panel's determination on undue hardship grounds. That case applies equally to here. There's no substantive distinction between the two cases. In any event, this petition was untimely, as Supreme Court properly found. The final agency determination that the petitioner challenges here is the March 7th reasonable accommodation denial, because that's the final agency action that inflicted an actual concrete injury on her that she could not redress through further administrative action. No matter what she could do, she could not change the outcome of that reasonable accommodation determination.
Well, could she have changed it by, within 7 days, getting vaccinated and then retaining her job?
Well, getting vaccinated, Your Honor, would have amounted to compliance with that administrative determination.
Why shouldn't the clock start running from the actual termination date?
So two reasons, Your Honor. First, it's not the administrative determination that she challenges here. If you look at her petition in the record here, pages 13 to 16, it's all about the denial of the reasonable accommodation on March 7th. And then secondly, as I noted to your colleague, this is the final agency determination here with respect to the reasonable accommodation determination. While she could have gotten vaccinated or she could have extended her leave without pay, both of those actions amounted to accepting and complying with the agency's determination.
What you're saying is that what she's really challenging is the denial of the accommodation as opposed to the termination.
Correct, Your Honor.
Didn't one almost necessarily lead to the other?
Not necessarily, Your Honor, because she could have complied with the vaccine mandate and continued working.
Anything else? Thank you.
Thank you, Your Honors.
First things first, I had the brief opportunity to review Hogue. Let's be clear, Hogue is a Christian. This woman is a Jewish woman. Clearly, the
So Christians
sincerity
can
of
have a religious objection to taking a vaccine?
I'm sorry, Judge?
So a Christian cannot have a legitimate reason to oppose a vaccine?
Well, according to Hogue, that would be correct. Hogue said, this court said in Hogue his Christian beliefs weren't sincere enough. It had nothing to do with undue hardship. And
So it had nothing to do with him being Christian. It was about whether the religious belief was sincere.
And that would be the inappropriate analysis.
Okay.
New York City human rights clearly states, first, the analysis has to come to undue hardship, not looking at reviewing the sincerity of their religious belief.
Well,
Furthermore,
the DOE has submitted a statement with regard to what the undue hardship would be, which goes back to my point that there were over 3,300 religious objections to taking the vaccine, not teachers, people within DOE, and to replace 3,300 people to do administrative jobs versus the jobs they were assigned to do and not be in the presence of others who had been vaccinated would inure to a hardship to the Department of Education.
Judge, we'll never know that because the issue here is they use the wrong standard for undue hardship. Two things, it's error of law. They use the higher federal de minimis, minimal standard. New York City, New York State have never adopted the minimal standard. We've always had a significant hardship standard. The record here, page 293, paragraph 33, says the city of New York applied the wrong standard. The record here, record page 47, shows it was a minimal burden standard. My client, we will never know from this record what standard was actually applied. If, in fact, the position statement, the inadmissible hearsay under any other circumstances was denied, it would have been irrelevant. But because it's now, we're allowed to have inadmissible, unsigned, undated hearsay to determine somebody's constitutional rights, we can look at that, but we don't know what standard they use because that position statement does not include the proper standard.
Thank you. Marquez versus 171 tenants.
May it please the court, Jessica Smith for Defendant Appellant 171 Tenants Corp. At the trial of this labor law matter, plaintiff's credibility was critical to the issues of both liability and damages. Plaintiff claimed that he fell from a ladder, but his fall was unwitnessed. 2 weeks later,
Can you tell us how the decision of the court to not allow a hearsay statement that was not pertinent to medical treatment and diagnosis is error? Because that's the issue.
So the statement, I would disagree with the proposition that it is hearsay. This statement was that it was a slip.
Did it say the patient said?
It does say patient states in that. It says patient states, slip, fall. That's how the trial court interpreted slip, fall, and that.
I thought that wasn't clear whether it was the patient who stated.
It did say PT, patient state, PT, as the abbreviation. So in this instance, we have the plaintiff claiming that he fell from a height after the ladder twisted. We have this ER record stating plaintiff states slip, fall. And he attributes only a right knee injury to the slip, fall. So if plaintiff had fallen from a height and sustained the additional injuries he claimed versus slipped and fell and, for instance, taken a knee, that would be germane to medical treatment. And regardless, I would
Say that again. I'm not following.
Sure. So plaintiff here claims he fell from a ladder. In the record, there's...
Is there anything that controverts that he fell from that ladder?
Well, Mr. Pareja's testimony, it was unwitnessed, and he testifies that, in fact, that the circumstances surrounding that accident was not as plaintiff described.
He did not. You started by saying he didn't see the accident, right?
Right, but...
So he doesn't know. He shows up, and the man is on the floor. Am I right?
He says
So
that
the only evidence I have in the record is from the plaintiff himself, right?
An unwitnessed fall does not automatically mean that plaintiff succeeds.
And an unwitnessed fall is not at all fatal to a labor law action.
And
we
I
have so held that a lot of times.
I'm not saying that it is fatal.
Okay.
There was a critical tribal issue of fact that was required to be determined at this trial. Mr. Pareja testified that, in fact, when he came into the hallway after plaintiff's accident, there was no spilled paint all over the floor like plaintiff claims. He did not clean plaintiff off as he
And the jury had that and yet decided the other way.
However, that filters in to the issue of the handcuffs. The handcuffs here.
Well, the handcuffs, let's talk about the handcuffs.
Yeah, sure.
So it was defendant's attorney that requested the warrants, correct?
That is
It
correct.
was defendant's attorney that was questioning Mr. Parejas, who sat there handcuffed incredibly, and defense counsel said nothing, correct?
That's correct. He did
Parejas repeatedly said, "Why am I cuffed?" Yet defense counsel said nothing, correct?
The defense
The
counsel.
court said nothing, correct?
The court also
And
did
now
not
after a
say.
$6.1 million verdict against you, now it's a problem.
The issue here is that Mr. Pareja, by pleading, whether the court interjected or whether plaintiff or whether defense counsel objected, his pleading with the court to remove the handcuffs deprived the defendants of a fair trial.
But when that happened, the defense counsel say, "Judge, why is he handcuffed?"
Well,
Is the
he did
answer
not-
no or is the answer
No, the
yes?
answer is no. He did not object. I'm fully willing to concede the fact that there was no objection in this record to the presence of the handcuffs. However, the issue, the purpose of making an objection is to raise that there's a problem that the court needs to address. This problem was before the court. Mr. Pareja was pleading in front of the jury for the removal of the handcuffs. He did
Counsel,
this-
we are in this situation because of the defendants. And now the defendants want relief from a situation they created and did not object to, despite the witness. This was a civilian who was brought to a trial in handcuffs.
Your Honor.
And not one time did the attorney who asked for him to be arrested say anything to help him, even during his own pleas. So why should you be heard now?
There is an obligation to all parties for the judge to maintain within the courtroom the fairness of the trial. It was incumbent upon the judge to do his own analysis to determine that the presence of the handcuffs during the testimony was reasonable. There is no indication on the record that the trial judge did that beyond the fact that he deferred to the sheriffs. Yes, the defendant did exercise its right to ensure critical testimony was produced in a live format by asking for the enforcement of the subpoena. They are allowed to do that under CPLR 20.
I agree with you, 100%. In fact, not something that's foreign to the member of this, to me, okay? When I was a trial judge. But the moment that witness is in the courtroom, take the cuffs off. They're not a criminal defendant.
And it was
There was nothing what on the record was there that would have established some kind of security risk
absolutely.
that would have made defense counsel think, no, I shouldn't help the witness that I had arrested and brought in out of these handcuffs.
There was nothing, but the trial judge had the obligation under the cases that we cited, including People v. Mendola, to make that determination and to control the fairness in the courtroom. I'm not disagreeing with the fact that the defense did not make that objection.
Counsel, despite the fact that the witness testified while handcuffed despite his pleas, one could reasonably argue that his testimony was favorable to you, yet it was rejected by the jury. What do you want us to do about that?
The jury was not given a fair opportunity to weigh the competing credibility of plaintiff and Mr. Pareja due to the presence of the handcuffs. It was not.
I don't see how it affected the plaintiff.
Mr. Pareja was the key defense witness who explained that in the aftermath of the accident, there was no paint on the ground. The reason why that matters is because plaintiff testified that he was standing on the ladder painting the crown.
Right, so that testimony favors defendant. So what you're asking us to believe then is that despite the fact that he was there handcuffed, he gave favorable testimony to you, that the jury didn't believe him because he was handcuffed. So he was lying when he gave favorable testimony for the defense.
No, that is not what I'm saying. I'm saying the jury did not have an opportunity to fairly weigh his testimony. I'm not saying that he was lying due to the presence of the handcuffs. It's that the jury drew negative conclusions from the presence of the handcuffs because they were not allowed an opportunity.
But if they were drawing that negative conclusion, then that would operate in your favor.
To the negative, well,
Other than the fact that the handcuffs were present, which I think we can all agree is problematic, was there any prejudice outside of that? Because as my colleague pointed out, the testimony was favorable to your position.
the testimony, but the issue is here that there's an unwitnessed accident. The key factor for the defense is not someone who saw what happened. It's someone who saw the aftermath. Yes, he was able to testify, and he did testify favorably, but you have that testimony of Ms. Pareja going up against plaintiff's testimony that the ladder twisted and he fell, and he was lying on the floor covered in paint. So that is the credibility determination that the jury would need to weigh.
Except that really the issue is whether there was a secure ladder, whether the ladder was affixed so that someone using it would not fall, or whether there was a spotter present for an unsecure ladder.
The issue.
At the end of the day, that's the only issue on a labor law fall off a ladder case.
No, I disagree. And in fact, on the verdict sheet, the number one question was, did the plaintiff fall from a ladder? That's what the jury had to determine. If the accident did not happen as plaintiff stated, and in fact he was not working on the ladder, then there's no labor law 240 liability. And that circles right back to the ER record, which said slip fall. So had that been admissible, the jury would have had further evidence even beyond what Pareja was saying to discredit plaintiff's
Your
testimony.
position is that that notation on the medical records, a slip fall, that was germane to treatment. So the fact that it was a slip fall as opposed to any fall that resulted in injury, that was somehow going to make a difference to the doctors that were treating him.
Yes, because if he had stated
They
that,
would have treated him differently if he said I fell off a ladder?
well, yes, they would have evaluated him for the multiple injuries that he would have stated had he actually explained that he stated multiple injuries. But instead, he said, 2 weeks ago, I slipped and fell, and I injured my knee. My knee hurts, my right knee. That's all that's stated in there. And that gives a plausible alternate version for the jury to accept, in addition to Mr. Pareja's testimony that, in fact, plaintiff was not on the ladder and did not fall covered in paint.
Well, he couldn't say that because he wasn't there. All he can say is, I didn't see any paint. But you'll have time on rebuttal, because we're way over time on you.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff respondent. Let me get to the,
Let me ask you this question, counsel. In terms of this issue with the handcuffs,
Yeah.
right? If we accept the fact that it wasn't preserved, but was it so prejudicial that this court should intervene at this point and maybe and do something about that?
So, Judge Pitbrook, my answer is going to be absolutely not, and I'll tell you why. Fundamental error is a difficult thing to get, and the reason it is because preservation is not some trick that appellate lawyers use. If you look at Barry against Manglass, what the courts are saying is, look, you are generalists. In New York jurisprudence, you have to know all 120 volumes because you're judges. We're specialists. We have to know 12 books. It's not a big deal for an attorney who has the case, who knows the case is coming up for trial, to tell the judge, hey, that's a problem. It's not some trick where you can look at a problem after the fact and say there's fundamental error. And it's not even.
And the reason for that is to give the judge an opportunity to correct.
That's exactly what Barry against Manglass says. It's designed to prevent the exact type of claim that's being made here, where lawyers can look in the conference room at a record over coffee and say, oh, that's a mistake. We didn't tell the judge, but we're going to say it's fundamental error. I'd also point out just personally, I've argued fundamental error, and I'm not 0 for 5, I'm not 0 for 10, I'm 0 for about 2 decades. So it's a really hard thing to do, and the witness is their witness. Now, they're saying that Mr. Pareja is their star witness. By the way, just so we're clear, Mr. Pareja also said unequivocally, plaintiff said he was on the ground, he fell from the ladder, his knee hurt. And here's the key, the pièce de résistance, 760, the ladder was, quote, shaky. So, I mean, to say that this is harmful error that's sufficient to throw out a jury verdict doesn't make any sense to me. With respect to the medical record, I know that some of the members of the panel said that. I don't think this says slip at all. I think this says status post. It's on 1676, line 6, and it won't matter anyway because you decided this issue. It's Mosqueda against Ariston Development Group, 155 AD 3D 504 at 505, quote, moreover, the party admission exception to the hearsay rule does not apply. Any statements in the medical records allegedly attributable to plaintiff does not qualify as an admission unless the individual who recorded it were to testify that it was the plaintiff's statement citing to Michael against Flatbush. They admitted they were never calling anyone. I have no idea how a judge can commit reversible error by giving a 3-day adjournment when the defendant asked for 2 days. I'll ask you to reject that. And with respect to the damages, I just want to point out, if a 33-year-old plaintiff, 44 or 45 at the time of the accident, if you look at the testimony of our radiologist talking about his actual musculoskeletal system, I just wanted to read the words to you. He said, quote, every surface is beautiful, that's Struhl at 549 to 550, except the areas where he got hurt. Our verdict with respect to pain and suffering with 5 surgeries, right? 2 knees, fusion, it's light. I'm aggrieved. We should have appealed. It was a mistake. And my adversary is going to say to you, well, you only had 20 years of pain and suffering, not 33, which you got on the medicals, which, by the way, we lost $2 million on. I would point out that you decided a case called Abreu, where you said that was against the credible weight of the evidence. So with respect to the damages, if anyone's aggrieved, it's me. I certainly can't ask you to do anything. I didn't appeal. We should have. It wasn't done. But this is a fair verdict, and you shouldn't touch it at all. If you have no more questions, I'll sit down. I'll let my adversary talk to you.
Thank you.
Thanks for listening to me.
Just briefly returning to the medical record before moving on to damages, while my esteemed adversary is fair to give his representation of what he thinks is stated in that record, the trial court disagreed, and I believe that is on page 338.
Let's
Go ahead, please, go ahead.
let's assume we agree with you that the notation says slip and fall. Would that necessarily mean that the record was admissible under the various exceptions to the hearsay rule?
No, but the fact that it is attributed to plaintiff, and just referring back to my earlier argument on the fact that if he had noted that he fell from a height, that would have been a relevant factor, and here he's just stating that he fell from a slip and fall. And actually, I think it's I believe it's Williams v. Alexander, the Court of Appeals case that plaintiff, in fact, relied upon in his brief. It's the idea there they did not find that the statement was admissible, but the issue was whether it was a car or the particular car. And there they were looking to say the fact that that first car was rear-ended by a second car was germane to medical treatment. And they said, no, it's just that he was hit by a car. And I would say here, the slip and fall is saying a car versus, the second car or some sort of
Is
explanation.
it possible for someone to slip and fall off a ladder that is twisting and going down? Is that possible that
It
a person?
is possible for someone
I mean,
to-
I would say the ladder started going down, and so I fell off the ladder. But someone else who perhaps is not as sophisticated will say, I slipped and fell off the ladder, right?
If he slipped and fell off the ladder, then his fall would not be caused by a failure to provide adequate
Of
protection.
course it would. If he says the ladder was shaking and I slipped and fell off the ladder, it's because the ladder was not secure,
The plaintiff
which
did
is
not-
required by the labor law.
Plaintiff did not testify that he slipped and fell from the ladder.
Said the ladder twisted, was shaking, and he fell off the ladder.
Yes.
That does not mean that he didn't sense that as it was shaking, his legs slipped.
Well, it
To
was,
me, the two are not inconsistent necessarily. So if he said, I slipped and fell on the floor, that would be something different. I slipped and fell on ice, that would be something different. But he doesn't even say where he slipped and fell in that statement in the medical record,
he just,
right?
does just say he slipped and fell.
Okay.
But if I can move on to damages.
Well, actually, you're out of time, but I think we've got it, and thank you so much. We have your brief and your record. U.S. Bank National Association versus Barker Project. You may proceed.
Good afternoon, Your Honors. Diana Rubin, appearing on behalf of appellant defendant, Barker Project LLC. Defendant appellant's appeal from a court order of the lower courts denying defendant's appellant motion to serve a late answer, or in the alternative, compel plaintiff respondent to accept defendant's appellant answer. The reason being is that appellants were negotiating and engaged in settlement discussion with respondents.
That's not a basis to not answer, though.
Yes, Your Honor, we initially claimed within our papers that we were not served, but aside from that, a respondent was negotiating, and we understand that respondent should have responded.
The date that you referenced in terms of the settlement negotiations, that was August 10th of 2021, but there wasn't any service effectuated until August 12th. So how does that affect your inability to answer, the August 10th negotiation? Or was there something after that it wasn't in the record?
So, appellant had the obligation to respond to the summons and complaint by November 5th. It appears to be that appellant was served with the papers on October 10th. We had filed a late response to the complaint on December 1st, 26 days later. Now, prior to that, yes, parties were negotiating, and they had been negotiating from the 2020 action with respect to, it's in fact 2020 action and the 2021 actions were identical. And those, the first action had resulted in settlement, whereby $1.8 million were paid for this.
Your position is that because you were negotiating on the 2020 action and then it continues into the 2021?
Correct, because the 2020 action and the 2021 actions, they're identically the same. Both actions were to foreclose 8 properties. Subsequently, after the discontinuance of the 2020 action, the $1.8 million were paid off for the release of the 3 properties.
Except that the amount that was provided based on the numbers of the mortgages, it didn't correspond to the amount owed. No. So you didn't pay off even the 3 mortgages that they claimed they were paying off.
Your Honor, we had submitted together into that motion 3 payoffs letter.
I know, 3 payments for, I think it was $600,000
$600,000 each.
Except that the debt was higher than that.
But
So
that
it
was
satisfied nothing.
right. But they were able to negotiate the release of those particular 3 properties, not the release of
And what document do I have in the record that says that?
the payoff demand. If I
I'm
may.
sorry, what are you referring to, the checks?
No, I am actually referring to record 296 to 304, whereby the servicing company Shell Point had made a payoff, sent a payoff to the appellants.
Again, you're not listening to what I'm saying. I understand, and I know what you're saying, that they sent 3 $600,000 payments, right? So $1.8 million, correct?
Correct.
Except that the amount due was more than that.
It was more than that for the entire balance of
Yes.
8 properties. For the 8 properties, not for the 3 properties.
Right, so the note had been consolidated, correct? So the mortgage secured an entire indebtedness, wasn't severable.
What they had negotiated, the arrangement that was negotiated is that $1.8 million would be paid for the release of the 3 properties, and each check.
And I'm asking you, what document, let me finish. What documentation is there in the record that supports that they agreed that they would, in exchange for $1.8 million, release the 3 properties that you were speaking of?
There was no written agreement. There was an arrangement.
Okay, and that's a problem, right?
And that's
Big
why-
problem.
Yes,
So
ma'am.
you'll have time on rebuttal.
Sure.
You may proceed.
May it please the court. I guess the main issue on this case, as far as I can tell, looking at the initial moving papers in the lower court, is whether a conclusory affirmation of defense counsel, based on hearsay, is sufficient to demonstrate, to vacate a default in answering. I mean, when defense counsel mentioned that the time to answer expired November 5th, as opposed, and it was only so long, well, the actual time to answer for the main defendant, Barker Project, expired in later September because they were served separately from the other defendant, the guarantor.
So there was a
it was a little
default in
longer.
answering. It hadn't ripened to a default judgment, right? So
There was no motion for default judgment.
So the standard that we employ under CPLR 3012D is a little more forgiving than the standard under 5015A1, right? And we're
Well,
talking
to
about a
the extent
delay
that-
of a few months for
Right.
the main defendant. And so what other ingredients go into that mix about whether a party who's in a pleading default should be given leave to serve a late answer?
Good cause, reasonable excuse must be given.
Length of delay, willfulness,
Right,
prejudice,
but
how are you?
in this case, there was no reasonable excuse. There
Okay,
was
that's one
hearsay
factor, it's not
allegation
an
by
element,
defense
it's
counsel.
not determinative, right? So that certainly weighs in your favor, but it's not determinative. What about prejudice? How were you prejudiced by the defendant's delay in pleading?
Oh, I don't believe that was raised at all below in the lower court, but again, plaintiff was moving ahead in its foreclosure, and then this motion came up. So, it had to stop everything to defend this motion.
You may proceed.
But again, we're dealing with interest in real estate, liens on property, and as defense counsel admitted, that there's no document showing this division of these 3 properties agreed to by both parties. I mean, there's only one agreement in there, and it broke up the initial mortgage into 2 sections, 7 properties, of which these 3 of them were the properties involved here, and then 2 other properties on a different
Would the existing agreements permit a modification that is not executed in writing?
No, I don't believe so. From what I remember, they all have that standard clause in them. I
So
believe
so
this
that
one did
counts
too.
your
I don't have it here to
adversary's
see.
argument that we had reached an agreement, and so that's why we tendered the 1.8 million. What do you say about that?
Well, again, there's no agreement. They said there was an agreement, but they didn't say when it was reached, how it was signed. They admitted it was never in writing. So, I mean, and there's actually no real proof that the checks were actually sent. They were just pictures of checks. Who knows how long ago they were actually taken? But, so there's no proof of the delivery. There was no affidavit in or proposed answer in the moving papers. Again, the motion's now,
Does your
the motion
side
to vacate or defer.
deny receiving 1.8 million?
Well, they're not admitting or denying anything that was not alleged.
Well, they allege that they paid the 1.8
Well,
and that
in a
should
hearsay
have
manner.
saved those 3 properties.
In a hearsay manner. There was no affidavit from anyone who actually tendered the funds that was put in the mail. And I mean, and to answer you, I don't know exactly whether it was received or not,
Okay,
because we didn't get into that with the client. Thank you so much.
thank you.
Your Honors, to conclude, $1.8 million were tendered to the plaintiffs. They never denied receiving it. In fact, there was no opportunity for the plaintiffs to provide a cancel check because they were provided by certified checks, those funds. Your Honors,
So you can't get proof from a bank that a certified check has been cashed?
from my understanding, you cannot because it is a certified.
Sure you can.
Okay.
If a bank has negotiated a certified check that you issued from your account, you can check with the bank when that certified check has been negotiated.
Yes, that could be checked. In fact, the funds were withdrawn from the account. As far as
And what proof do we have of that?
we have none.
Okay.
To conclude, Your Honors, after submitting the motions to compel defendants to accept a late answer, immediately thereafter, plaintiffs moved for summary judgment, indicating that issues had been joined, answers had been accepted. And for that reason, given that there is a lot in stake, 1.8 million had been paid, plaintiffs never denied receiving it in their papers. And the short delay, the lack of prejudice to the plaintiffs, and substantial prejudice to the defendant would merit the fact to reverse lower court's decisions.
Thank you.
Thank you, Your Honor.
People versus Lamin Naji. My colleague, Judge Bahati Pitt Burke, is recused, and we will follow the rules of the court with regard to that should there be a tie, okay?
Good afternoon, Your Honors. Robin Richardson on behalf of Mr. Najay. We're here today because Mr. Najay was entitled to an evidentiary hearing regarding the legality of his arrest and the identification procedures and physical evidence.
Regarding the legality of his arrest, so my understanding is that there are two, for lack of a better term, two incidents here, right? Where there's an alleged sale of marijuana to one person, and then there's an alleged sale of cocaine and marijuana to an undercover officer. In defendant's moving papers, he denies the sale of marijuana to the individual, but then then does a general, I was doing nothing wrong at the time with regards to the undercover. How is that enough?
Yes, Your Honor. That's regarding the map hearing, which is the physical evidence and the arrest. So he does allege that he didn't pour marijuana into an individual's hand and then goes on to deny, that he was engaging in anything incorrect. This was a clerical error on the defense counsel's part. It was in a later motion to renew that those allegations were denied. But there are other ways to get a map hearing. You can either deny the participation in the alleged conduct, or you can suggest other grounds for suppression. And here, they have really strong grounds. And then the first and the main one really is that any description that was provided to the seizing officers was not reliable and was insufficiently specific to justify his arrest. This isn't a case like Warden.
How did the defense allege that?
Excuse me?
How did the defendant allege that in its motion papers?
Well, under Mendoza, you can only plead the facts that you have. right? And this is a situation where they have very limited facts, and actually when they filed their omnibus motion, the facts that they were given was even less, like in particular regarding the identification.
Right, but the defendant also knew what he was wearing when it happened, right? The defendant had his own independent facts. Did he use any of those in its motion?
Yeah, Your Honor, he could have said beyond what he did say, which was that his clothing was not distinctive and that there was nothing that his appearance resembled other people in the vicinity. He could have gone beyond that, but really the issue here is there are no allegations as to the vantage point of the officer that purportedly gave an identification to the arresting officer. This isn't a case like Wharton.
He was the undercover, wasn't he?
There was an undercover.
And the ghost? Was there a ghost here?
They
No.
don't.
So
say
if
that.
it was the undercover is the one who does the hand-to-hand.
But that's
Who
not-
better than him knows the identification of the person who he just bought drugs from?
There are no allegations that officer is the one who engaged in the hand-to-hand. In Wharton, they say the officer engaged in a hand-to-hand by
I'm
and bus.
confused. Was there evidence in this record that there was more than one undercover and anybody else on the scene, on the set?
It's not. That's not information that the defense counsel would have for sure. And in order, it has to be pled. It has to be properly pled. It has to say. I mean, who knows how many people were in this? I certainly don't know. It was never alleged in the charging documents that it was the same officer who engaged in a hand-to-hand. It could have
Are
been
you
somebody down the
challenging whether
street.
this was a confirmatory ID altogether?
Altogether, yes, Your Honor. And the finding that it was a confirmatory ID was based on the conclusory allegations by prosecution that this was a confirmatory ID.
Even if we were able to get to this issue, well, let me put it the other way. Can we get to this issue in light of your client's plea? Doesn't that foreclose this entire analysis?
In light of the plea?
Yes.
A waiver of right to appeal.
Thank you.
And the waiver,
yeah.
right.
So in light of the plea, yes, under the CPL, he could absolutely challenge this
Right.
After a plea. The waiver in this case is invalid. This is not a valid waiver. Mr. Najee admitted his guilt before the explanation of what the waiver of the right of appeal even
That
was.
may be true, but the fact that there was a waiver required here was no secret. And in fact, my understanding is that defendant and defense counsel had the written waiver before he pled guilty.
There is mention of a written waiver, and again, that's signed before he gets an explanation from the court. And the oral colloquy, it needs to be clear on the face of the record that the defendant understands. Here,
But it's the face of the record and the written colloquy together. Isn't that what the case law says? There's no magic language that a judge has to give, and that shortcomings in the colloquy can be cured by an effective written waiver.
yes, Your Honor, they can be cured. In this case, they were not. First, the written waiver is not a part of the appellate record. It was not in the record, and actually, when it was cited by respondent, I went and looked through the record again. It was not there. It wasn't in our internal trial records, and from my understanding, they found it on the 10th floor of Center Street. So this was something that was not a part of the record. It is referred to, but in this case, because the court only ascertained if he had time to review and sign the waiver, what really needed to happen is that he needed to ascertain on the record that he had time to read it and that he understood the waiver. And this is especially true for this.
What case law says that? That the judge has to ask, did you read it? Did you understand it? What case says that?
It wouldn't. In this context, it would be important because this is a client who did not speak English and was working with a translator. So the fact that he understood it is really important, especially if he signed the waiver.
Okay, go ahead.
Especially if he signed the waiver before the explanation of what the waiver was.
Okay.
Thank you.
All right.
Good afternoon, Your Honors. May it please the court. Robert Butlin for the people. So as touched upon when my adversary was arguing whether this court can even reach any of these issues, and the answer is they cannot. First, because of the valid appeal waiver. First of all, it was part of the record on appeal. There's no
I'm
question.
sorry, what did you just say?
The appeal waiver was part of the record.
Was
on
part of the record?
It was, yes.
From the beginning, or did it get added at some point in the proceeding?
It was absolutely not added at some point in the proceeding. First of all, it was, of course, referenced and used and admitted during the plea proceeding. And then Under NYCRR 1250.5 A and E, defendant was allowed to proceed on the original record, and poor person's relief also permitted defendant to proceed on the original record. And the original record is maintained on 100 Center Street at the 10th floor, and then certain things are photocopied for this court's convenience. But just because it wasn't photocopied doesn't mean it wasn't part of the record. It was considered by the court.
If we don't have it, we don't have it.
It's also,
We can't assess something that's not in front of us.
of course, Your Honor, and I did share it, and I believe it is also common practice in this court that if something
That's the
isn't,
key right there, because that's what I remember reading, that you did share it, but it wasn't part of the original record. Is that right?
it wasn't part of the photocopied.
Of what was sent to us.
It wasn't part of, yes, correct.
It might have been somewhere on Center Street.
Yes, but that did not make it,
Okay.
just because it was not photocopied doesn't mean it wasn't part of the record on appeal. That's our position. And in any event, the appeal waiver, it was valid. Justice McGrath separated its discussion of the rights defendant automatically forfeited upon his plea of guilty with the rights he was agreeing to, the appellate rights he was agreeing to waive. Of course, there were 2 times the court made sure that defendant had received and reviewed the written waiver. The written waiver has his signature, which also confirms that he understood it.
It was in English?
The written waiver was in English.
Okay.
Although-
Did anyone offer him a Spanish one?
Sorry, repeat that, Your Honor?
Did anyone ever offer him? Well, no, he's not Spanish, right? He's French.
Your
Was a
Honor-
French one offered to him?
Not to my knowledge, Your Honor. And I also don't believe the records shows that he doesn't understand English. Just because a interpreter is there, it could be for assistance, but there isn't any indication whatsoever that he didn't
Well,
understand.
we aren't going down that slippery slope.
Sure, Your Honor. But his
You cannot even pretend that this court would go down that slope. It doesn't really matter. Maybe no, that's not going to happen.
Of course, it matters whether he understands things, but there's nothing in the record that he didn't understand anything. And I believe the written waiver was reviewed with his interpreter, too. I believe that was confirmed.
Counsel, this was a negotiated plea that included the waiver of right to appeal, correct?
Yes, Your Honor.
Which means defense counsel and the prosecutor discussed this plea, and which leads us to believe that he spoke to his client prior to going into the courtroom and taking the plea.
Exactly, Your Honor. Yes. And then another reason this court also cannot reach at least the issue is whether the defendant was entitled to a hearing on the confirmatory ID is because that issue was not preserved. Although the defendant did challenge it, they raised no arguments whatsoever in support of that, let alone the arguments now raised on appeal. They could have filed a reply to the people's motion, so they had enough knowledge to contest our basis for that. And as Your Honor addressed earlier, it was the same undercover officer who did the hand-to-hand transaction. There's only...
You're saying that, but where in the documents does it say that?
Admittedly, Your Honor, it doesn't spell it out specifically, but I believe that the documents do say that it was the same person because there's only mention of one witness. It also says that...
It happened a minute later and about 200 feet away.
Sorry, repeat that, Your
It
Honor?
happened a minute later and about 200 feet away.
Did the criminal court complaint refer to it? Typically, the criminal court complaint will say something about there being a hand-to-hand with the undercover and there being a confirmatory ID thereafter, or something to that effect.
Yeah, the complaint talks about that. It says the undercover officer's number. It says there was a hand-to-hand transaction. And then in the people's response to the omnibus motion, they elaborate on that he merely was just confirming after defendant was arrested that it was in fact the same person. This is just like Warden. It's on all fours with Warden. I see my time has expired and I've gone beyond it. Do Your Honors have any further questions?
Thank you.
Thank you.
You have 2 minutes.
I just want to touch on this, that how much this is not like Wharton. The real crux of Wharton is that they stated that it was the undercover that engaged in a hand-to-hand drug sale. We have no idea where this other undercover was. We don't know if it was a ghost. We don't know. It's.
Is your issue that you don't know where the undercover was when he allegedly made the ID, or that you don't know who it was that made the ID?
We don't know who. We don't know who made the. We don't know if it We don't know either of those things. and the crux under
What's
Boyer.
the crux of it? Because I've never seen a complaint that says the undercover was 10 feet away from a building. They
Yeah.
don't say the location.
It
of the
says, they say that an undercover engaged in a hand-to-hand, and then it says he was identified. And, to state that he was merely confirmatory.
No, they usually will say, and there was a confirmatory ID, et cetera, et cetera.
I'm not, I don't think that was in the criminal
okay.
complaint. I don't think so.
And I don't remember seeing the complaint on this one. but
And in their response, they didn't say it was the same officer who engaged in the hand-to-hand, and that could have been alleged. It wasn't. The court relied on grand jury minutes and in order to find that the ID was merely confirmatory, but that's an error. Under the CPL, it's the defense, not the court, that's entitled to be served with facts that support the confirmatory ID. And there are reasons for that. It's because grand jury testimony is not elicited with these suppression issues in mind, and it's not subject to cross-examination. So the court really made an error there. And regarding preservation, it's not, the defense can only plead as much as they know under Mendoza. They have no idea what undercover and from where, and it's.
But you don't need to know that. But what defense does have to do is give a sufficient factual basis to permit a court to grant a hearing.
Well,
and at the end of the day, that falls on the defense.
For sure, under the Wade hearing, they pled as much as they could regarding the identification. They can't say where. And regarding preservation,
I think we've covered this already. Thank you so much. We're out of time. 35th Street versus 7 and Up Clothing.
Sean Sabetti for the appellant. Good afternoon, Your Honors.
Good afternoon.
May it please the court. Your Honor, the essential issue before the court is whether a commercial lease agreement that is expired, could it be labeled as an extension or modification of the lease? My client signed a commercial lease agreement in 2009. In 2014, that lease expired.
Could you bring the mic up a little bit so that we can hear you better?
Oh, yes.
All right.
And in 2014, that commercial lease agreement expired. Subsequently, landlord provided a document which was labeled as extension and first extension and modification of the lease. The first lease had a notarized guarantee clause attached to it, but the extension and modification did not have any consented guarantee clause attached to it. Therefore,
I thought it contained a provision titled guarantee, which said, upon the execution of this first extension and modification of lease agreement, the good guy guarantee executed by Jidanian and Sasson shall be deemed amended to include the obligations hereunder.
Yes, but that's the language, that's not the language that is used typically for a guarantee clause.
It doesn't matter what language is typically used. The question is, does that language state a sufficient extension of the guarantee along with the modification? And tell me why it doesn't.
Maybe in an extension of the lease, yes. But when the lease was expired, the landlord should have given them another lease agreement, not an extension of a
But despite this argument, there was another extension, or whatever you want to call it.
Second one.
Similarly, on the second extension, landlord used the same language and same paragraph to say that you have a guarantee clause signed. The first guarantee clause was notarized, had a specific language indicating.
But didn't the parties, by their actions, treat these as extensions, whatever you want to call it now, that they were in fact extensions?
Well, it is our position that they were not extensions. They were this first extension of the lease modification was a new lease, and this court has already issued a decision that in Loho versus Batista, that an extension requires a new language for the guarantee clause. You cannot carry over the previous guarantee clause into the new lease agreement.
Why not?
Loho versus Batista basically says once you have that new lease, the guarantee clause expires.
So I think
Didn't
you
your
miss.
client, I'm sorry,
No, go ahead.
didn't your client sign both the first and second modification?
Signed but not notarized, as it was required in the first guarantee clause. He signed it, but he was not aware that he was he's completely unaware of the law that says the new lease requires a new guarantee clause.
But didn't it contain a provision titled guarantee again, the second one, April 30th, 2017, that said, upon the execution of this first extension and modification of lease agreement, the good guy guarantee executed by Gideon and Sassone shall be deemed amended to include the obligations hereunder?
Yes, shall be deemed, and it's sort of like a confirmation or ratification rather than actual
I'm
guarantee
sorry, Counsel.
clause.
He read this and he signed it, and you're saying no.
But he should have been notarized if it was going to be a guarantee clause.
So your argument is because it wasn't notarized, it's not good?
No, because the guarantee language was not there. It basically says the previous guarantee clause is going to be ratified and confirmed. That's basically in sum and substance.
That happens a lot, counsel. That this is not a unique situation. And you keep on referencing Batista. But in Batista, the lease modification changed the guarantor's original obligations. And so we said there where the obligation, where the guarantee has now been, the nature of the guarantee has changed, there the guarantor now has to sign the new guarantee to be bound. That's not what happened here. It just continued the same guarantee from the original lease. So I want you to think about that, and you'll have time to respond to that on rebuttal.
Good afternoon, Your Honors. May it please the court. My name's Gary Wachtel. I represent the plaintiff respondent. First, I'd like.
That first extension was entered into after the original lease expired.
We don't know, Judge, because the date of the expired lease was April 30, 2014, and the next extension is dated May blank 2014. So I don't know if it was delivered to the tenant the day before the lease expired and wasn't signed until after, one day after the lease expired. But what I want to bring out to Your Honors is that this issue was never presented to the court below. I've scoured the record. I can't find a single sentence submitted in the pleadings or in the opposition papers to the summary judgment motion that said that the first lease expired before the first lease extension was executed. So this court can only respectfully rule on an application that was made to the court below. In addition, Your Honor, the defendants filed an answer containing every possible carbon copy, bare legal conclusion as an affirmative defense, and yet still didn't mention anything that has been argued on this appeal. The first lease extension and ratification of guarantee was signed by the tenant and signed by the two guarantors. If you look at each document, there are three signatures on each document. So the guarantors had to put their ink pen to paper 3 times. Once as an officer of the tenant and twice as the individual guarantors. They knew exactly what they were doing. It's in the record at A104 to A106, and in the record A107 to A109 for the second lease extension and ratification.
Sir, did their signatures need to be notarized in order for those guarantees to be binding?
No, not at all. There's no case law that says that it has to be. And again, not argued to the court below. So appellant ignoring the twice ratification of guarantee obligations, I believe, is misunderstanding the holding of White Rose Food versus Soleil. Holding that the guarantor is relieved of the obligation if the note is modified without the guarantor's consent. But the court in White Rose held that the guarantor, in fact, was liable because the guarantor executed the document both as the guarantor and on the promissory note this very same day. It was the very same person who agreed to the cross-reference provisions contained, and therefore the court held that the party could not disavow his obligations by subterfuge. Same thing happened here. The appellant signed the extension and signed the ratification of guarantee. To adopt the appellant's arguments would abrogate the spirit of the lease and guarantee, would violate the manifest intention of the parties, would mask the true nature of the obligations and the relationship. It would be form over substance. Lastly, Your Honor, Your Honors, since the court's determination in the court below, Judge Ronnie Abrams of the Southern District of New York determined in Melendez versus City of New York that the New York State Guarantee Law under the Administrative Code 22-1005 is unenforceable as violating the contract clause of the U.S. Constitution. And therefore, if appellant were to argue that somehow the appellant was protected under the guarantee law, he didn't argue that in the appeal, but he did argue that in the court below. That issue is now moot.
Thank you.
Thank you.
The appellant in the lower court vividly denied every allegation made in the complaint. And therefore, in response to whether he agreed to the allegations contained in the complaint, we state that he denied. However, Your Honor, in the case of Liberty Taxi Management versus Ging Chairman, the court says even if the appellant fails to respond to the summary judgment motion, it is the obligation of the court, obligation of the movement for the summary judgment to demonstrate the allegations that there are no material issues of fact. But here, the lease, the difference between lease and extension of lease is paramount that we really need to focus.
Thank you.
Thank you, Your Honor.
Archives LLC versus Volpe. You may proceed, counsel.
Thank you. If it please the court, Paul Gruber, Bora Goldstein, Altshuler, Naines, and Goydell for Appellant Archives LLC. This is an action concerning a residential guarantee, and we believe that the court improperly denied judgment against the guarantor for the period beginning May 2020 and ending in August 2022, when the tenant, in fact, vacated the premises pursuant to a negotiated settlement in housing court. Fact of the matter is the guarantee.
The terms of the lease that you're relying on that would extend the guarantee once the lease has been terminated, what are you exactly relying on? What particular section?
We're relying upon a couple of things here. One is the fact that the guarantee covered both the payment and performance of the lease. And one of the obligations that the tenant had under
I need you to explain, because as my colleague was alluding to, the lease had very specific definitions with regard, under the guarantee, with regard to what constitutes a supplemental agreement.
That's
So
correct.
I want you to explain to me, under that provision.
Well, that was the
how-
guarantee.
Can I finish?
Sure.
How, under that provision, the facts that happened here at the end of the lease when your client chose not to provide a renewal, how that falls into this provision.
The language with respect to supplemental agreements appears in page 113, and that's in the guarantee rather than any of the leasing documents. And that includes to extend to any time period under the lease, including without.
But there was no lease, right? Because again, your client chose not to extend the lease. So at the end of the lease term, there was no lease.
Except that there were two things.
You had a tenant who didn't leave.
That's correct.
But there was no lease.
That's correct. And as we argue in point 2 of the briefs, the tenant, the terms and conditions of the lease were implied into this
Implied?
holdover.
No,
Yes,
no, no,
Court
no,
of
no.
Appeals.
We don't do implied on this issue, right?
No.
Doesn't our case law say that if a guarantee is going to extend to a holdover tenant, then the guarantee has to specifically say so?
That's what it says.
And
but
that does not say that here.
we're arguing slightly differently here, that this was more than the obligation to pay. It was also the obligation to perform and
Under the lease.
under the lease.
But again, there was no lease.
The tenant was obliged to leave at the end of his lease. That's crystal clear in the lease, and I will give you the page number.
So that would have entitled you to certainly a grounds for eviction.
And we did, and we got hung up in the pandemic, and eventually we recovered possession. The question is whether the guarantor is responsible. And what the argument is that he was required to also ensure performance, didn't do it. The second argument is that
But why is he required to ensure performance after you terminate the lease or you serve notice that you're not going to extend it? Isn't his obligation end when you say lease over?
So he would be responsible for any rent or duty or any obligations not paid by the tenant up until the last date of that valid lease that he is a valid guarantor for. But once your client decided, we're not going to give you a renewal lease, on the end date of that lease, they're off the hook.
That's not
based on this guarantee.
I don't believe that's exactly what the guarantee says. I don't think it's what it meant. And also, I would point out that the notice
Well, we got to go by what it
Okay.
says,
The
right?
understood.
Okay.
The notice that the court's referring to was the Real Property Law 226C notice, and the wisdom of the legislature on this, and I'm not exactly sure why they put this in here, but it seems relevant here. In 226C, the first paragraph, sub A, is that the occupant's tenancy extends until the end of the notice. So certainly, at a bare minimum, we can argue that we're entitled to much more than that.
Till the end of the
guarantor,
notice?
What?
Till the end of the notice, you said?
Until the end of the notice, yes.
But that's notice for eviction.
That's it. No, that's not a notice of eviction. That's a notice simply advising that it's non-renewal. I think the 226C notice is still kind of misunderstood at this point. Can I finish?
Yes.
Thank you. The 226C notice basically requires that a landlord who wants to increase the rent more than 5% or elects not to renew a deregulated lease, which is the case here, has to give a notice and the amount that this is what I plan to do. And the amount at that time depends upon how long the tenant's there. Here, it would be 90 days. The notice was given, the election not to renew the lease was made less than 90 days before the end of the lease. So under the statute, and whether this language was designed to benefit the tenant or the landlord, I really can't tell you from it, and it hasn't been explored yet. The occupancy rights continue until the end of the notice. That is that my client, and assuming there weren't any pandemic restrictions at the time, couldn't have sought relief at the end of the lease. He would have had to wait till the end of the notice. Again, this is it's a secondary argument here.
Okay, thank you.
We can explore more later.
All right, thank you.
Good afternoon, Your Honors.
Good
May it please the
afternoon.
Court. Jeffrey Klarsfeld for the respondent, Jeffrey Cohen. Your Honor is correct. That's exactly what Judge Getz did here. He held my client liable under the guarantee for a couple months of rent up until the expiration date, and he held under this specific guarantee. There was no liability after it expired. The guarantee never once uses the word holdover. The landlord is seeking liquidated holdover damages. Supplemental agreement is defined in the guarantee as all agreements between owner and tenant, and then it goes on to specify 5 or 6 categories.
Counsel, could the stipulation that was entered into in August of 2022, could that be looked at as a supplemental agreement?
That was a stipulation that was long after the tenant, that was 2 years after the tenant had held over, and was an agreement for the tenant to vacate. So that's way after the fact, way after the lease expiration. It's still a holdover period. It's still liquidated damages that the landlord is seeking, and this guarantee doesn't use the word holdover or liquidated damages. The case of Elite Gold was more than 15 years ago. The court there was faced with almost an identical guarantee and was very clear. If you want to seek holdover rent, put the word holdover in the guarantee. And in fact, this court a couple of years ago issued a decision, and I think it's the Zazula case, where the guarantee said exactly that. It said the tenant is responsible for a bunch of stuff, including holdover rent. And Your Honors affirmed the lower court and said the tenant is responsible, or the guarantor rather, is responsible for that. We don't have this in this guarantee. This was drafted by the landlord. It was signed 2 lease extensions before the tenant ultimately vacated. This was signed in connection with the original lease. There was an extension. There was a second extension. When that second extension expired, that's the time period that Judge Getz held.
I believe one of the arguments articulated was that the provision that would have required the tenant to pay 125% of the rent in the event of default, right?
Correct.
That should have put you on notice that you would be responsible for a holdover. What do you say to that argument?
That's the argument, but that was the exact scenario in Elite Gold, and this court rejected it more than 15 years ago. In fact, in Low Hope against Batista, which was discussed in the prior case, there's dicta that goes on beyond the issue. There was an issue in Batista, which was when a lease expires, can you have a guarantee that continues past that? They went on in dicta and said, even putting that argument to the side, you can't have holdover rent under this guarantee, because if you wanted that, you needed to put the words holdover in the guarantee.
Well, did they do that in paragraph 1 of the guarantee by saying that the guarantor would guarantee to the owner full and punctual payment and performance of the above referenced lease? And the key word there being full. And wasn't U&O captured in paragraph 16 of the lease and specified the rate of U&O? So would we be reading the word full out of the guarantee?
I believe that's the exact language that was in Elite Gold. If you look at the trial court decision, that exact language, and I cited in my brief, that exact language was used in Elite Gold, and the court said that's not enough. You need the word holdover. Liquidated damages beyond the expiration of a lease is not performance under the lease. That's something else. So, no, I don't think that covers it, Your Honor. Okay. If you have nothing else, Your Honors, thank you.
Thank you.
One word about Elite Gold. There's a distinguishing factor, at least I think it's important, is that in Elite Gold, the landlord and the tenant thereafter created a month-to-month tenancy. We don't have that here. It's a distinction between this case and that case. Secondly, the
I
full
don't think that helps you.
No.
I honestly just
Yeah.
don't think that even helps you.
Yeah.
You'd be in a better position if you could argue that there was a tendency.
Yes. There was a tendency. There was a tendency that, as we said, implied and by the statute, and also the full and punctual payment and performance of the tenancy. The guarantee is the guarantee. I agree. The fact of the matter is that the lease also very plainly said that the tenant had to leave at the end. The guarantee has to encompass that situation, and there's a case I cite in the reply brief, PEG from the Second Department, which I think relies upon authority from this court, which basically says that you can't have the situation where the guarantor is somehow let off the hook because the tenant decides he doesn't want to leave and doesn't want to pay.
But that's why our case law says you've got to include the language about being responsible for holdover into your guarantee so that you cover that scenario.
Certainly magic language does help, Your Honor, to use your phrase, and I don't disagree.
Touché.
I don't disagree. It's 90% of what I do all day, frankly. But however, if the language that is actually utilized and construed by the parties applies, then you are supposed to enforce the obligations of the guarantor and not find a reason to relieve the guarantor. Unless there are any
I'm
other
sorry,
questions.
is your friend correct that the landlord drafted the guarantee?
I have no reason to believe that it didn't.
That also doesn't help you. Okay.
I understand that,
Thank
but it
you.
is what it is.
I agree. Have a good day. All right. Yes. All right. People versus Alberto Vallejo. You may proceed.
Thank you. Good afternoon, Claire Glass with the Legal Aid Society on behalf of Albert Vallejo. The Level 3 designation in Mr. Vallejo's case below was an overassessment of his risk of reoffense in light of the mitigating information offered by defense counsel below. And I'd like to start just by discussing Mr. Vallejo's family connection. Mr. Vallejo's family, and specifically his mother, his sister, and his niece, have stood by his side since his arrest, throughout the pendency of the case, his 13 long years of incarceration, and they were present at the SORA hearing and offered letters in support of Mr. Vallejo, not just to show that they're still by his side, but also to offer him a place in their homes. And that is significant and sets this scenario apart from many others where individuals in Mr. Vallejo's circumstances would be released to perhaps a group home or a men's shelter and in a position really to start over.
So is that enough in a case like this where the facts simply are egregious and he scored a 160, which is almost at the top?
Well, Your Honor, it's our position that under the third prong of gelati, in the totality of the circumstances, taken with the 10 years that Mr. Vallejo will be subject to post-release supervision, as well as his age.
You make a lot about that post-release supervision, and I'm not saying that it's not valuable, it is. But that didn't stop your client from engaging in 2 sexual acts in prison. And he was in prison. So why should we think that post-release supervision is going to be any better?
Well, certainly, Your Honor. And what I'll say is that, the tickets that Mr. Vallejo received while incarcerated are encompassed under the risk assessment instruments assessment.
That's the point that I'm trying to make.
Yes, and the point that I am, making in response is that the post-release supervision, the support of his family when he's in the community, not...
He had support of his family before, and that didn't stop him, right?
Well, yeah, Your Honor, I actually,
7 years in prison, and he decides to pull out his penis to a female nurse in 2020. So how does that give this court any confidence that he has any insight?
Well, Your Honor, what I'll say is that it's very different to be supported by one's family in the home of the family, surrounded by community, as compared with the isolation of incarceration. However, I don't say that to discount the seriousness of those tickets by any means, but...
And the tickets are the least of it, right? Because, I mean, The allegations underlying why he's here, as my colleague said, are egregious, and that's being kind. That's a nice, pretty word.
Certainly, this is a very serious case, and I don't mean, to discount that by any means in making this argument. But what I am arguing is that under Gelati and the totality of the circumstances, even in light of the facts of this case, the fact that Mr. Vallejo will return to the home of his family.
Counsel, you keep talking about these Gelati factors, and you specifically mentioned the third factor, which is where the weight, the balancing test needs to occur. How a 14-year-old victim restrained and raped, and you're saying that that is balanced out by the fact that he has family ties, like as my colleague indicated, were there prior to this incident even occurring.
Kidnapped and sex trafficked. This isn't just, I'm going to rape her for myself. I'm going to now treat her like a piece of meat and have other people rape this young little girl repeatedly.
Again, Your Honor, I don't mean to downplay the seriousness of the allegations whatsoever, but
160. What is the level? What's the cutoff for level 2?
It's 110, Your Honor.
And we should drop someone from 160 to a level 2.
That
we should drop him 50 points.
Yes, Your Honor.
Based on these facts.
That's correct. And if I may just respond briefly with respect to the Your Honor's comment about PRS.
Why don't you do that on rebuttal?
Sure, thank you.
Good afternoon, Noah J. Sexton for the people. Your Honors, my adversary keeps bringing up Gelati, the factors of Gelati, the totality of the circumstances. As Your Honor pointed out, this is a balancing test. So let's balance this. Defendant, after being convicted of torturing, raping, and functionally enslaving a 14-year-old girl, goes to prison and proceeds to go on what almost seems like a deliberate path of monstrous behavior while in prison. On top of those 2 sexual offenses in 2020 and 2021, we have 18 Tier 3 and 28 Tier 2 offenses. That is some of the worst my office has ever seen. The only remorse that he has alleged, and in a way, this just, I don't really know why they were brought up by the defendant, because they just speak against him, are these letters talking about remorse.
In those letters, he doesn't accept responsibility, and it's almost, you could almost read it as he's blaming the victim. He tried to help her not prostitute herself.
I think it's a good example. A wise person once said, everything said before the word but does not actually mean anything. He says, oh, I'm sorry, I didn't mean to hurt you, I didn't mean to do this to you, but you wanted it, but you wanted me to give you a baby, but you shouldn't be prostituting yourself, but I only pled guilty because I didn't want to go to prison for life without parole. There's no genuine remorse here. And just speaking briefly to the post-release supervision point, yes, he will have a lot of services available to him under post-release supervision, and that's great because clearly he needs it. That said, it does not encompass enough to make sure that he doesn't hurt anybody again. The potential damage to a victim, the potential damage to the community is incalculable. We need this enhanced checking in. We need these residency restrictions. We need to keep him away from children and vulnerable people because that's who he exploited in the first place. If Your Honors have no further questions, I'll rest on the papers.
Thank you. Since he finished early, I'm giving you his time. Okay? Go ahead.
Yes. So just first to reply, Mr. Vallejo will be subject to the same residency restrictions as a level 2 or a level 3. Furthermore, the effect for public safety will essentially be the same. The purpose of SORA is to track individuals who've been convicted of sex offenses, to allow their information to be published on the internet. The same will be true. The same community notification will be taking place whether Mr. Vallejo...
The difference is the length in time, right?
No, actually. Under a level 2 or a level 3, Mr. Vallejo will be subject to the registry for the rest of his life. The difference is just the number of check-ins that he'll have per year. And given the extent of the PRS, the decade...
And his residency isn't a level 2 less restrictive in terms of where he can live than a level 3?
It's not actually, Your Honor, because of the age of the complainant in this case. No, he'll be subject to SARA, and in fact, his family members have offered to move to a SARA-compliant residence so he can live with them, which again, I think is another aspect of what makes Mr. Vallejo's circumstances a bit set apart from the average person
So
in his circumstances.
that doesn't change regardless of what we do. They can still move, he can still move with them. It doesn't matter then.
Well, it does affect Mr. Vallejo's likely, just his reintegration into the community. If Mr. Vallejo is actually comparatively well-positioned to succeed upon release with the support of his family.
It's really hard to hear you say that with over, 42 infractions?
Well,
I agree with your adversary. I've never seen so many on a SORA case. Never.
And no remorse, counsel. Where's his remorse?
So, Your Honor, may I just
yes.
answer that? Thank you. So, while those letters are internally inconsistent, they're referenced in the board's case summary as being apology letters. He does apologize within them, for both his behavior in and out of
But the
incarceration.
does kind of wipe out everything ahead.
Well,
It wipes out everything ahead.
That's not our position, certainly. And also, Mr. Vallejo participated in a significant amount of treatment while he was incarcerated,
Was that successful? How many times did he have to do that?
So, Your Honor,
before it actually completed?
So Mr. Vallejo enrolled in treatment 3 times while incarcerated. The first stint he completed was just under a few days under 2 years. And then he was removed. He re-enrolled once again. He was removed.
Now, he was removed because of his behavior.
Well, he was removed because of disciplinary issues that were
Because of his behavior.
Correct, which were unrelated to the programming itself, which is really important both under the Court of Appeals case law in People v. Ford, which requires intentional rejection of the substance of the programming, not just, disciplinary issues. And this this court has followed People v. Ford on a number of occasions, including in People v. Hart, where it noted that poor participation and progress isn't tantamount to a refusal to accept responsibility, and also in People v. Solomon, where this court held that even alongside other failures to accept responsibility, one's participation in programming, and in Mr. Vallejo's case, that was for almost 3 years, is some indication of acceptance of responsibility. So, for these reasons, we ask that you reduce Mr. Vallejo, grant the downward departure to a level 2.
Thank you.
Thank you, Your Honors.
Calderoni versus the Board of Managers of 260 Park Avenue South. Let me put your time up. Hold on.
Sure, no problem.
You may proceed.
Hello, good afternoon. My name is Nicholas Vivanti with Gallo Vitucci and Carr. May it please the court. It is the defendant appellant's position that the lower court should have dismissed the entire complaint because the plaintiff commingled their claims between the individual and the derivative claims. Under both Udall and Tooley, bringing a derivative action is allowed, but that the Tooley test is not even reached because of the commingling, making it impossible for a court to.
How did they commingle?
The plaintiff commingled them by including both the same kind of damages, same kind of relief sought in both claims. They're commingling their own personal interests with the interest of the condominium unit. You can see this in the record in their complaint. They asked for the same relief in the breach of contract claims, the breach of fiduciary duty claims, going down the list. In addition to that, the derivative claims should not have been brought in the first place because, as plaintiff admits, they never made a demand on the board to.
It was futile. They kept on asking for repairs to be done and nothing happened.
Well,
Their entire apartment units have been damaged.
They asked for action, but they never made an actual demand. Under Court of Appeals.
How
case
many
law-
times do you have to ask the board, the manager, there's water leaking from the roof? It needs to be fixed. How many times does that have to happen?
Well, the board did address the demands. There was certain problems with getting access to the pool, with getting
Access to the roof? They had a problem getting access to the roof?
the owner of the penthouse B was arguing with them about what kind of repair needs to be done, whether the entire pool needed to be removed. It wasn't just they didn't ignore the demands. They were trying to get trying to address it, but it was slower than the plaintiff might have wanted. But it wasn't, and it wasn't futile under the Court of Appeals case law. It shows that you have to ask, you specifically ask.
No, not it. Counsel, you don't always have to ask if your ask would be futile.
Correct.
Okay? So that is a determination that the court below makes and that we get to review.
That is correct, but the futility wasn't properly pled in the complaint. There's three cases, three prongs to a test whether a demand would be futile, and none of those were specifically pled in the complaint.
Because these owners did not say that they asked for repairs to be made and they weren't? They didn't say that?
I'm sorry, repeat that?
The owners whose apartments have been damaged
Correct.
from this condition, in their complaint, they didn't say that they asked for repairs to be done and none were forthcoming? They didn't say that in their complaint?
In their complaint, they specifically say that they did not demand this action. On the record, on page,
Wait a minute. I'm asking one question and
Sure.
you're saying something else.
my apologies.
It would help if you answer my questions,
Just
right? So my question was, did the complainants and did the complainant say there's been damage to my apartment due to water
Correct.
from the roof and no repairs have been taken by the building or the manager?
yes, that's correct.
Okay, so they did say that.
Yes, they did.
Okay, they just didn't use the magic words, the demand was futile.
Well, under case law, that needs to be not magic words, obviously, but they do need to make an actual demand and not just make ask. They need to show that demand was made or that it's futile under the case law.
Okay, we're not going to argue about this anymore.
Fair
Go
enough,
ahead.
Your Honor. Regarding the temporary receiver, we do not believe it should have, we do not believe should have been appointed in the first place. There was no, at the time it was appointed, the water damage was stopped. The leak was stopped.
Were the
And
repairs done?
the repairs weren't completed, but the water damage was done.
No,
So there's no further damage that was occurring.
counsel, an apartment that is saturated in water doesn't stop incurring damage because water has stopped leaking. The water that is in the apartment continues to degrade the surfaces within the apartment. So damage continues even though the water is not dripping anymore.
Well, as shown in the risk report, in page 865 of the record, that damage was stopped under that report.
The owners were able to go back into their apartments after years of not being in there?
I don't believe they were back in their apartments at that point.
They're
but
still not, are they?
I'm not sure at this point.
You're not sure.
I don't know that.
You represent the board and you don't know whether these people are in their apartment.
At the moment. Sorry, one sec. Unless there's any questions, I rest on my brief.
Okay.
May it please the court, I'm Randall Racy. I represent the plaintiffs and respondents who are the actual owners of the condominium units at issue. If I may, I would just like to bring this argument back to the point that the plaintiffs are still out of their units. October 22nd this month will mark 5 years since the water from the swimming pool on the rooftop crashed into Erin Calderone's apartment and forced her to leave. The Department of Buildings issued a vacate order on that unit in June 2019. That order is still in place. The two other units at issue, the evacuations weren't quite as dramatic as Aaron's, but they've still, Nancy and Stephen Kraus were forced out in January 2020. Anna and Sarah Schwartz, who were sisters, were forced out of their unit, which is below Aaron Calderone's, in July 2021. They had mechanics liens placed on their units because the board or their agent did not pay the contractors that they hired to come in to do emergency repairs. Those were removed only after we addressed it to Judge Perry in the motion court, and the condo's lawyer said, oh, of course, we'll take care of that, and they did, thank you. But the idea that I would ask my friend here and anyone interested, including your honors, just to take a look at the photos taken by Anna Schwartz of her unit and Aaron Calderone's units, which are at pages 172 through 178 and 184 to 186 in the record, showing the extreme water damage, the unusability, the unlivability of their apartments, and then contrast that with the glossy photos of Unit 4I, which at the time was owned by the wife of the president of the board and was featured in the New York Times Homes for Sale section. The board has a duty, fiduciary duties, independent of its contractual duties under the bylaws, to treat all unit owners fairly. They're not allowed to favor the majority at the expense of a minority, and that's what they've done here. We have 3 units in a building with more than 100 units that are subject to the water damage. There's some outside that area, but most of the people are fine, and they're just not willing, or they haven't been willing to put through the substantial assessments needed to pay for it. They've used various excuses for that. I'll be happy to address those if you want me to, but I think it's kind of ipso facto. There's a failure here of management. The board has not been functioning. At the time we asked for a temporary receiver, in the spring of 2022, the most recent board meeting minutes were from November 2019. In opposition, the condo's lawyer said that they came up with a couple of more annual meeting minutes, but the board requires, the bylaws require the board to meet monthly and to make minutes. They were basically asleep at the wheel, and they were leaving their agent, their managing agent, Maxwell Cates, to run things with a limited budget. They came in opposition to the temporary receiver, saying they just restarted the repair work and they had funds to do so, but when Judge Perry asked them if they had the funds to finish it, they said no.
And at that time, they were only done 55% of the work, correct?
That's what they said, yes. Now that the temporary receiver has been appointed, it's been more than a year. He has made some progress. They're still out of the apartments, the roof still isn't repaired, and the delay is that they owe so much money that even with the new special assessments, they're still in arrears, and the contractors logically don't want to come back and do work until they're paid for the work they've already done, and they're assured of the work that they're going to perform. So I don't really think there's much more for me to say about the temporary receiver unless you have questions about that. As far as the derivative claims, as Judge Perry found, we've clearly distinguished between the direct claims in which the individuals, the plaintiffs were injured individually in their units, and the general claims regarding the common elements of the building. The point of defendant's argument is basically that you can't have the same misconduct create both direct and derivative damages, and that's clearly not true. There's case law from this court saying just the opposite. Here we have damage to the water leaking through the common elements, which is damming the common elements, creating derivative claims, and as you can see from the record, and you're obviously aware, it disproportionately impacted our clients. So that's just not a valid argument. As far as the demand futility, I think Your Honor addressed that very well. I agree with you. As far as the duplicity duplicateness of claims, they're arguing that because we have contract claims under the bylaws and we're ipso facto precluded from making tort claims. That's obviously not true. There's plenty of case law from New York Court of Appeals decision in the Clark Fitzpatrick case, 1987, and more recent case law from this court. I won't cite them, but stating that the same acts that generate a breach of contract claim may also violate a claim independent of the contract, even if it's related to the contract. The fiduciary duty claim is the most egregious. They clearly have fiduciary duties that may exist in tandem with, but are independent of the obligations.
Does the relief sought on the breach of contract claim have to be different from the tort claim in order for both to be viable simultaneously?
No, they've argued that, and they argued a case, Palatori, I think, in which the court noted that fact in that case. But I've seen, and I look for this, I've seen no case that says the damages have to be different. In fact, there are cases in which we've cited in which the damages at least appeared, based on the opinions, to be very similar, if not identical.
Why would that not be duplicative then?
Pardon me?
Why would that not be duplicative then? If the remedy is the same and the causes of action stem from the same facts, why would that not be a duplicative cause of action?
Good question. If there were unanimous, I'm sure you needed that reaffirmation.
I wasn't being sarcastic, I was being honest, thank you.
I understand. If there were no dispute as to what the obligations were under the bylaws, that would be an easier question to answer in their favor. But they're disputing what they're obligated to do under the bylaws. In some areas, they agree with us, but in others, they disagree. So at this point, we're allowed to keep our claims active. The fiduciary duty claim is unique because in the derivative claim, we're alleging that they breached a fiduciary duty to maintain the common elements. In the direct claim for breach of fiduciary duty, we're arguing that they breached their duty by favoring the majority of the owners by not imposing the massive special assessments that are required at the expense of our clients.
Got it.
And that is a different kind of breach.
Okay, thank you. You have 2 minutes.
Sure. First, I want to address that the board was never not functioning. The board is supposed to meet 4 times a year, not monthly, but despite that, as attested to by Stuart Ornstein in his affidavit, they met unofficially monthly, but they did meet 4 times a year as required by the bylaws. The same affidavit states that although there was not enough assessment for the repairs, that was later rectified. Moving on to whether, while you can have both types of claims, when you can both have the same action, same action or inaction can lead to both types of claims, both individual and derivative. That doesn't mean that this case there were no commingling. They asked for the same damages. They show same damages and same relief for both.
Well, no, the damages, the relief for their personal claims is fix my apartment, make me whole. Their relief for the common elements is fix the hallways, fix the common elements. Those are 2 separate reliefs.
In their complaint, though,
one is personal, one is for the whole building.
in the complaint under both claims, both the individual claims and the derivative claims, they asked for both plaintiffs' units to be fixed and common elements to be fixed.
Yes, okay.
That's is our position.
You're saying they had to file 2 separate lawsuits?
Or properly show that which actions were, which cause of action were, or which damages and which relief.
Oh, I think they did that, but go ahead.
Okay. And unless the court has any other questions, I'm happy to rest on my brief.
Okay, thank you so much.
Thank you.
New Millennium versus Progressive.
Good afternoon, may it please the court. This is a a no-fault matter.
Gentlemen, can you take that outside, please?
I'm sorry.
I'm sorry.
No, it's-
You may proceed.
This is a no-fault matter involving a 2020 motor vehicle accident in which the injured person sustained injuries, was insured under a insurance policy with Progressive Insurance. There was a $50,000 policy. The issue that stemmed here was services that my client rendered in December of 2021, submitted it to
So we're familiar with the facts. The issue here is
Priority payment.
is priority, right?
65 3.15. So the question really becomes, does it mean what it says? Does it mean what the appellate term first department made believe it said? The issue here is, quite frankly, the regulation, and as I placed in my brief, it only applies to basic economic law. So it applies to the first $50,000 in coverage. Anything after that, or 75, there's oval, but the APIP it doesn't apply to. And the construction that respondent is suggesting, construction that the appellate term first department suggests, essentially relegates 65 3.15 to an appendix, which is an unneeded, unnecessary body part. Regulations are supposed to be construed like statutes. We read them all together. If you adopt essentially what the lower arbitrator, well, the master arbitrator said there's two different versions of how it should be read, so he put his hands up, Judge Kelly put his hands up. At the end of the day, the regulation should be read how the regulation should be read. The appellate term second department in many cases said that. In fact, this court, if you were to look at the Kensington and the DTG case, pretty much said, we look at priority when a bill is received or when it's verified. And the argument that the appellate term first department makes that says, well, if you deny a claim timely, it's okay. If we look at the NIAC case itself, the Court of Appeals told GMAC, you're going to pay over policy because you didn't properly issue certain letters. The fact of the matter is that the regulations say what the regulations mean. No fault strictly construed against the insurance carrier. It always has been. It always will be. And what we're asking the court to do is essentially align this court with the second department, both the second department, the appellate term, and to be consistent with this court's two opinions in DTG and in Kensington.
But are we allowed to look at this de novo or to look at this with an eye towards rationality and here the arbitrator considered a precedent? Maybe it's certainly not the only precedent, maybe it's not, doesn't represent the weight of authority on the issue, but the arbitrator did point to a precedent supporting the lower arbitrator's determination here.
That's a great question, Justice Higgett. And the fact of the matter is no fault is looked at through an Article 78 lens, not through an Article 75 lens. There's an extra level of review. And I would actually point this court to the recent case of matter of American Transit versus Smart Physical Therapy, where this court said, well, based on how this court rules, it doesn't matter what another court rules. And they relied on other cases, other IME no-show cases, where this court actually reversed the Supreme Court and said, well, it's the law in this judicial district that if you don't show it on IME, there is no coverage regardless of timeliness or as the second department, the fourth department, and probably the third department.
So you're talking about, I'm kind of losing you because
I am sorry, I don't want you to-
about issues that have nothing to do with the issue before us. So
Okay,
I need you to focus.
I'm sorry, the analogy here, Judge, to answer Judge Higgett's question, I went off on a tangent here, is that this court essentially follows, if it sees that the law is not followed, this court will, on issues of substantive law, make a decision. So to answer Justice Higgett's question, if this court believes that 3.15 means what it says, then this court, in a numerous global liberty cases, will step in and reverse the Supreme Court, which would reverse the arbitration. Thank you.
Thank you.
Good afternoon, Your Honors. Jamila Shukri for the respondent, Progressive Causalty. Your Honor, the question here is whether the personal injury protection benefits contracted for the $50,000 should be paid in above what was contracted.
Well, I think the issue here is the priority, right? Because yes, we can understand that the arbitrator cannot award beyond the policy's limits. Once it's exhausted, it's exhausted. But I think his position is that they had priority. So why don't you address that?
priority of payment does not mean first in time, first to be paid. Priority of payment apply only to verified claims. When the claim is verified, that first claim verified should be paid first prior to other claims, as long as all claims are still within the 30 days pay or deny, and as long as the time told to pay other claims. Meaning a bill number 4 can be paid before bill number 1 as long as the 30 days stand and as long as the bill number 1 was properly paid, told for verification.
That doesn't seem to be consistent with the statute.
The statute mandates 30 days to pay or deny. The statute gives instruction how to toll the time to bill and deny by giving certain days and certain times to issue verification requests.
Okay.
So if we look, the statute is telling us 30 days to pay and deny.
So let me see if I understand what you're saying. So let's say 50 claims end up at your client's office on February 1st. They have until March 2nd. February is only 28 days. They
Or
have till
20.
March 2nd, right, to make a decision, yay or nay, to pay or not, correct?
Correct.
Okay, so those 50 claims that arrived on the 1st, you pay them as they are verified?
Yes.
And so no matter what order they came in?
Okay, verified, yes. No matter what order they came in, as long as I am still within the 30 days.
Okay.
That means the bill that I received on February 1st, if I look at the bill, or the adjuster looks at the bill and say, okay, I have an independent medical examination that denied this service for this provider. So they have 30 days from February 1st to deny it.
Right.
Second bill came on the same day, but the fee schedule was not properly applied, and they needed more verification from the provider. Then they have 10 days to issue the first verification, wait another, 15 business days to issue a first verification, wait.
So let me ask you, if you seek additional information on that request, what date is that request being considered? On the original date that it was received, or on the date that the additional information that you have requested is received?
Received, on the day that it was received, because at the time that it was received, it can be considered a fully verified claim, and now subject to payment or deny or request additional verification if not received. On the other hand, when there is a contract and the law mandate the $50,000 to be paid, the carriers may not hold liable for bills that they received properly processed, properly denied, timely denied for future litigation that they might be faced to pay in above the $50,000. That means we are creating coverage, more coverage in monetary amounts than what they should be paid. And if the carriers will keep the unpaid balance of the bill and say, oh, I'll keep it for the future when they sue me, so I will pay it because I don't want to pay above the 50, then it's very prejudicial to the insured that they kept his bills not paid or kept some amounts not used to promptly pay other providers.
But is that procedure that you just laid out, is that consistent with 65-3.15?
Yes, because only verified claims can be paid. And verified, and they have to be paid within a time limit. If there's no verification and it is verified upon receipt, you have the 30 days. That doesn't mean priority of payment, very simple, is first get in, first get out. It doesn't work like that. First get in.
I'm sorry, can I just ask one more question?
Yeah, yes.
If an insurer was to request further verification, right? That's the way that it's set up right now, and the way that you explained it, and the way that it works with the statute. That's not something that they can just do just to delay payment, right? Because there'll be some sort of safeguard against that.
Verification is requested, should be requested in good faith and pursuant to what they received. For example, sometimes the provider will bill reinsertion for acupuncture, but it's not documented. They build it in the bill. I want additional $25 for this session, but it's not in the paper. So the carriers, they issue verification requests. Please provide medical reports showing the second insertion. That tolls the time until provider will provide them with the medical reports. Provider delay compliances that delay the time to pay and deny. And the recent amendment to the no-fault regulation, if they never receive the requested verified documents, they have 120 days to pay, to deny from the first request.
Got it. Okay, thank you. All right.
I agree with the fact that a claim that's pending verification, the date of receipt is the date the verification is received, and the hypothetical that counsel raises, and I think this court reached it in Kensington where there were EUO demands. The verification was when that last EUO demand letter was sent, and the court said, okay, well, it's on that date that we look as to, what's left on the policy. Let's look at this case. Bill was received 1/4/22, denied 1/13/22 on the basis of medical necessity. According to the regulation, as I read it, and I think as we all here read it, it says when that bill is fully verified, which is 1/4/22, we say how much money is left in the policy. And that's what the inquiry really is. So at the end of the day, nobody's ever resolved that issue, which means that the remedy should be a remand to Supreme Court for a framed issue hearing or evidentiary hearing as to how much money was left on the policy on 1/4/22. I think that's where this case really should go. That's where it starts and that's where it ends. If we're going to be faithful to the reading of 65(3.15, if it says what it means, which is basic economic loss and nothing more, that's where we go and that's where we end. Thank you, judges.
Thank you. Chelsea 8th Avenue versus Chelsea Milk LLC. Hang in there, we're almost there, guys. Last people on the calendar always have it the worst. Sorry about that.
Oh, I've
All
been
right.
there many times myself.
Huh?
I've been there many times
I know.
myself.
All right, you may proceed.
Good afternoon, Paul Gruber again for the appellant. There's no question here that there was a default under the lease and that the tenant vacated well before its end of a term without obtaining the written surrender required by paragraph 24 of the lease at page 52 of the record. So the court below, in denying summary judgment on liability without any explanations, clearly erred in our view. The question that remains here is the two issues that are argued here. One, the liquidated damages provision, and second, whether the fact that the transfer to an additional LLC after the lease was made means anything. Let me answer the second question first. It doesn't. The lease says clearly at paragraph 33 in the definition section that an owner includes a successor by virtue of a transfer. And if the lease didn't say that, Real Property Law 223 would have covered that. As for the liquidated damage provision, the question you have to address here, and the provision here basically obliges the tenant on a default to pay the balance of the lease term less any sums collected by the landlord. And this lease has until 2025 to run, and the default occurred in 2021, if I recall. There are two questions with the liquidated damage clause you have to ask. One, could damages have been anticipated when the lease was made? This lease was made in 2015. We're in quite a different world since 2015, so I would suggest respectfully that the answer to that question is no. And secondly, is the amount being sought grossly disproportionate to the probable loss? All that clause provides for is what the landlord would have collected had the lease been performed. The court below's denial of summary judgment for without prejudice to discovery, and there's no clear indication what discovery would show here. The lease is clear with respect to both liability and damages. Was plainly erroneous. We ask the court reverse and grant the motion.
Thank you.
Thank you.
Good afternoon, Your Honors. Brett Van Benthuizen for Respondent. The primary issue in this appeal is actually whether or not paragraph 18 of the lease permits the appellants to recover future unpaid rents at the present time. That's a purely legal question. Determination of this issue, which is essentially contract interpretation, it does not require factual affidavits, as the appellant repeatedly argues. It's a legal issue for the trial court to decide based on the plain language of the lease and the case law. Here, the lease language and the case law fall decidedly in respondent's favor. The language of the agreement states plainly, this is paragraph 18, liquidated damages shall be paid in monthly installments by tenant on the rent day specified in the lease. That means that the damages clause that the appellant is relying on would require it to collect those damages each month, just as it would collect rent. The cases have held that this language, quote, indicates that a landlord is not entitled to future rents, but rather must wait until these rents accrue on the rent day. That's 88 Third Realty. That case examined the same language provision, or the same language in the same provision at issue in this case, and it in fact quoted the same relevant language of the default provision, which states, as I said before, that liquidated damages shall be paid in monthly installments by the tenant on the rent day specified in the lease. Going back some years, 1944, the First Department considered this same exact provision. And it squarely held that payment is not accelerated. The damages are being payable from month to month. The appellant ignores this argument and ignores this case law and the plain language of the lease and says that all future rents, as my esteemed colleague said, the lease will come due sometime in September 2025. The appellants argue that all future amounts are due now in the present. That's simply not the law based on the language of the lease and the case law. In the appellant's brief, they cite two cases that would arguably permit this type of conduct, which would give the landlord a potential windfall here. However, those cases are easily distinguishable. In Trinity Center, there's no evidence in the record that the default provision being considered there was the same as the default provision being considered here. And critically, in Trinity Center, both leases had expired by the time the decision on summary judgment came down. Here, that's obviously not the case. The leases will not expire until 2025.
So the landlord can sit back, but could walk out of here and withdraw this action and sit back and then demand the rent to be paid each month as it accrues until the expiration of the lease?
Correct, Your Honor. It would be under the liquidated damages provision. That's correct. There's a second case, 9th Ave Realty, but again, that case is easily distinguishable because, again, there's no evidence that the default provision is the same, and in that case, the defendant actually defaulted, so the court didn't actually consider this issue. On the way to the case law and the plain language of the agreement, the court's denial of summary judgment should be affirmed. Now, just briefly on the additional plaintiff and the attorney's fees provision, there's clearly a factual dispute as to Chelsea 261's relationship with the lease and relationship to the plaintiff. Chelsea 261 is not a party to the lease, and there's been no showing that they were an intended beneficiary. So on that basis alone, the appellant has not made a prima facie case entitling it to summary judgment. Similarly, with respect to its attorney's fees claim, in no instance is a party entitled to a blank check with respect to attorney's fees. The appellant did not submit time records to show what its attorney's fees would have been, reasonable or otherwise. On the reply, the appellant argues that it should be entitled to some sort of judgment as to liability on attorney's fees. That position should be rejected because, as the lease holds, only the prevailing party is entitled to attorney's fees. If you don't have any further questions, I'll rest. Thank you.
Okay, thank you.
We've established that the plaintiff is entitled to prevail in this proceeding. It's very common for the court to defer the amount of an attorney's fees award until all is said and done, and it makes its determination with respect to the merits. There's no reason why that shouldn't happen here. The argument with respect to the additional tenant to comment, I think, is completely without any legal basis. As pointed out, the lease addresses the effect of a transfer on the definition of owner in the lease. And again, real property law 223 is crystal clear that a successor owner has the same rights and liabilities. The particular relationship between these two tenants in common really has no bearing on whether or not this tenant should have been paying its rent to the landlord or whether or not it's been in default of its lease. As for the other argument, well, we're in the end of 2023, and certainly there's been no attempt by the tenant to make any payment. This court, I don't think, has addressed this specific argument directly.
Okay, we're out of time, so
Thank you. We cited something in the reply. Thank you very much.
we'll take a look at the record again.
Understood.
Thank you. Have a good night. And last but not least, Jabelki versus Board of Managers.
Good afternoon, Your Honors. My name is Enrico DeMarco. I represent the appellant in this case, the Board of Managers of Harborview Condominium. As the court has probably read my brief and my reply brief, I'll rely on that. The main issue in this case is whether or not Judge Engeron erred in not conducting a trial as to whether or not the corporate unit owner was an occupant of this building. There are affidavits submitted in this case in a motion to dismiss and in a motion to renew to re-argue. And the question
Why can't the judge just look to the language of the bylaws?
Well, the judge could look at the language of the bylaws, but the court couched its decision in factual determinations, and I'm submitting that the factual issues that the court cites in its decision, one, is not contained in any record or affidavit, and two, the affidavits create an issue of fact requiring the court to have conducted a trial on the CPLR 7804.
How is Lee?
Lee is an officer of the corporate entity, if anything.
How does that make Lee an owner?
Lee is not a owner of the corporate entity.
Isn't that
The
what is
corporation has
required?
to function.
Counsel, when the court is talking, you have to stop. Okay?
Yes, Your Honor, I'm sorry.
All right.
I'm sorry.
So, I've lost my train of thought, so go ahead.
You were saying, how is Lee, then, who's not an owner of the corporate entity, allowed to serve as a board member? I thought that's what you were.
How does he qualify? And what language in the bylaws would permit such an interpretation that an employee of a corporation somehow now qualifies as owner under these bylaws?
Because under our jurisprudence, we find corporations to be persons.
Oh, I know you're not going there.
Yeah, Citizens United. and
I
the
know
real
you're not
property
going
law.
there.
But Judge, the only way a corporation can be represented is by its employees, its officers, its owners. And
Does the bylaws say that a corporate owner can be considered for a board seat? Does it say that anywhere?
The bylaws say that the majority of the board seats are to be filled by owners. That's all it says. And I believe.
And owners is not defined in the bylaws?
It's defined in the bylaws.
And what owner definition would encompass the employee, not the corporation owner, the employee of a corporation?
The definition in the bylaws says that you have to rely on the real property law definition. The real property law definition of owner includes corporate entity, and my position is that a corporate entity can only be represented by its officers and agents and owners. And so it would be almost impossible then for a corporate entity
What
unless it was
what
owned.
document was included in the record to show that Lee is an officer?
There was a corporate registry, and there was the affidavit of Shen, who is the...
The corporate registry said what?
The corporate registry said that she was a manager or something. It's cited in the record. I don't recall now, Judge. I'm sorry.
Okay, all right.
Yeah, but there's a corporate registry, and there's an affidavit by Mr. Shen. The second issue why the court erred is because it relies on things that are not in the record or in any affidavit, and that's unfair.
Like what?
For instance, the court says that Shen said in his affidavit that the unit is mostly occupied by another entity that he also controls and owns called Metro Kids. There's nothing in his affidavit that says that. Then the court says that Shen said he occasionally manages. There's nothing in his affidavit that he says that. There's nothing in any record that he said that, and he never said that. So that's why I believe the court erred. And I'll rely on the remaining brief. I make a jurisdictional argument, but I'll rely on the court, on the brief. Thank you.
All right.
Thank you.
Excuse me, may it please the court, my name's Peter Salzar on behalf of the respondents. To address an issue that came up right away about Ms. Lee, that position by the board is simply indefensible. She's an employee of Mr. Shen or one of his many companies, and she's not an owner of the LLC Goldstein Fresh Meadow Realty that occupies, well, that they claim occupies the unit. It doesn't occupy.
So the units is a daycare center.
Correct. It's a community facility unit that specifically can only be used for education, health purposes, et cetera.
Are they a combined unit or
I
are they
believe so.
separated by a wall?
It's 2 units, but I believe they are combined.
Okay.
I don't know. It wasn't germane to our
Okay.
position.
All right.
But in any event, GFR doesn't occupy that unit. Metro Kids does. And to respond to counsel's statement, Mr. Shen admits Metro Kids occupies the unit, but as the court correctly found, he can only offer vague conclusory statements that GFR conducts its business in the community facility units. He never states what business that is. He never states.
So GFR owns the 2 units.
Correct.
And they have leased them to this daycare center.
Correct.
Is there any evidence in the record that the owners of GFR are also owners of the daycare center?
Mr. Shen states he is an owner of Metro Kids in his affidavit, correct. He has an
Okay.
ownership interest. But the issue in the court found that Mr. Shen doesn't visit the units. He's not an occupant. And he states in his affidavits on multiple occasions, Miss Lee is there all the time, but Miss Lee is his employee. Another point to make is Article 4, Section 2 of the bylaws that states that every officer of the board must be an owner. And she has been held out to be an officer. Sometimes she's stated as a secretary. At another point in a notice of a meeting, Mr. Shen named another employee, a woman named Ashley Fang, as a secretary of the condominium. So it's been unclear to my clients, the respondents, who actually is on the board at times, because Mr. Shen is simply putting employees who are not owners, are not occupants on the board. So there was really no question of fact here.
Wait, when he says that, he's saying they're secretaries of the corporation?
No, he's saying they're secretary of the board, an officer of the board.
Oh, okay. But that kind of puts the cart before the horse, no?
Correct. Well, they're not.
First, you have to be qualified to be on the board.
Correct.
Yeah.
And it isn't the respondent's position. If the respondents bought their unit in LLC, a sole member LLC, and they resided in their unit, they're an owner-occupant. If they sublease it, similar to what his clients are doing to a different entity, they're not an owner-occupant. It's very straightforward. There's no question of fact that needs to be interpreted under the bylaws of what an owner-occupant is.
Okay.
And in response, since counsel didn't raise the jurisdictional issue here, I won't raise it, but if the court has any questions, I'd be happy to address them. Thank you very much.
Thank you. You have time on rebuttal. You have 1 minute.
1 minute. So there was no evidence of a lease. The allegations are not vague or conclusory. You have to look at the affidavits. If you think they're vague and conclusory, then obviously I lose. If you find them not to be vague and conclusory, then the court should have done a trial. You don't require much to raise an issue of fact to conduct a trial. Secondly, Mr. Shen.
But it has to be a legitimate, real issue to go to trial.
This is a company that shares, there was no evidence of a lease, that shares the premises with another entity. And that is perfectly permissible. Just because he shares the space with Metro Kids doesn't mean that he's all of a sudden disqualified, he's no longer an occupant.
So you're saying there's another business operating out of the daycare center?
There's another business that he owns that operates.
Answer my question. Is there another business operating out of the daycare center in units, is it 2 and 3 or 3 and 4, whatever it is?
Yes, that's shared with Goldstein Fresh Meadows.
And am I correct that he's real,
What?
his affidavit lacks any kind of specificity
No.
about what that business is, exactly what it is he's doing in the same space as a bunch of children at a daycare center for educational purposes, as I understand that unit must be used for. So what other educational purpose is in the record that your client attested to, that I can hang my hat on?
There's mention in the petition that he occupies the units as a retail establishment.
Retail is not education,
No,
unless you tell me I'm selling books out of here.
Well, it doesn't matter really what he does. It's enough.
No, counsel, if you just said that it is correct that these units have to be used for educational purposes.
He said that.
Did you disagree with that?
I disagree that they have to be exclusively used for educational purposes. They could be used for other reasons.
Fine.
They're
All right.
shared. You can share it. And he didn't say that he doesn't visit the units. That's just not. I'm submitting the affidavit sufficient to warrant a hearing to show whether or not he was an occupant or not. And I'm asking it just to be remanded for a trial. If the court wants to hang its hat and say, you know what, there's a credibility issue, I don't think he occupied, it's fine. But conduct a trial. That's what's fair.
Thank you.
Thanks, Judge.